In episode 15 of the Supreme Court Opinions Read podcast, I'll be reading the Supreme Court's opinion in Waetzig versus Halliburton Energy Services Inc. The case was decided February 26, 2025. And as always, we'll begin with the syllabus. Gary Waetzig filed a federal age discrimination lawsuit against his former employer, Halliburton Energy Services Inc. He later submitted his claims for arbitration and voluntarily dismissed his federal lawsuit without prejudice under Federal Rule of Civil Procedure 41A. After losing at arbitration, he asked the district court to reopen his dismissed lawsuit and vacate the arbitration award, asserting Federal Rule of Civil Procedure 60B as the basis for reopening the suit. Federal Rule of Civil Procedure 60B permits relief from a final judgment, order, or proceeding. The district court reopened the case, finding that a voluntary dismissal without prejudice counts as a final proceeding and that Waetzig made a mistake when he dismissed his case rather than seeking a stay. The district court separately granted Waetzig's motion to vacate the arbitration award. The 10th Circuit reversed. Held. A case voluntarily dismissed without prejudice under Rule 41A counts as a final proceeding under Rule 60B. Part A. The court does not address Halliburton's argument regarding jurisdiction over the motion to vacate. The question whether Rule 60B permits reopening a case that was voluntarily dismissed without prejudice is antecedent to jurisdictional questions about the motion to vacate. The lower courts may address those questions on remand. Section B. Text, context, and history support the conclusion that Rule 41A, voluntary dismissal without prejudice, qualifies as a final proceeding under Rule 60B. Section 1. A voluntary dismissal is final because it terminates the case. This straightforward reading aligns with legal dictionaries from 1946 when final first appeared in the rule, and is confirmed by advisory committee notes to the 1946 amendment to the rule. The word final underscores that Rule 60B does not infringe a court's inherent and distinct power to revise its interlocutory decrees in an ongoing case. Halliburton's request to construe final consistent with jurisdictional statutes like 28 U.S.C. Section 1291, which gives the courts of appeals jurisdiction over appeals from final decisions of district courts, is unpersuasive. The finality concept in appellate jurisdiction serves a distinct purpose, preventing interlocutory appeals from impairing case resolution at the trial level. Finality under Rule 60B does not play a similar role. Unlike an appeal filed under the appellate jurisdiction statute, a motion for relief under Rule 60B is discretionary, not a matter of statutory right. Rule 60B therefore does not pose the same risk to efficient case resolution before the trial courts. The court sees no reason to import the understanding of finality that applies in the field of appellate jurisdiction to the different context of Rule 60B. Section 2. A voluntary dismissal counts as a proceeding under Rule 60B. Legal dictionaries from 1938 to present suggest that the term proceeding encompasses all steps in an action's progression. Other federal rules similarly treat proceeding as including all formal steps in an action. Halliburton and the court below assert that the term proceeding should be read in the context of its neighboring terms judgment and order, and because a judgment and order both involve some judicial determination of rights, a proceeding should at least involve some judicial action or conclusive determination of rights. Although it is true that statutory terms must be read in the context of their neighbors, that rule cuts the other way in this case. The proposed alternative reading would strip proceeding of independent meaning, as any judicial determination would already be in order. When Rule 60B authorizes relief from a judgment, order, or proceeding, the rule speaks in an ascending order of generality. The structure of the rule suggests that each term should be read as broader than what came before. Section 3. The court's reading is buttressed by historical context, as Rule 60B was modeled after a California statute previously interpreted to extend to voluntary dismissals without prejudice. See Hall v. Hall. Justice Alito delivered the opinion for a unanimous court. Federal Rule of Civil Procedure 60B permits a court, on motion and just terms, to relieve a party from a final judgment, order, or proceeding. The question in this case is whether Rule 60B permits a district court to reopen a case that was voluntarily dismissed without prejudice under Rule 41A. We hold that such a dismissal counts as a final judgment, order, or proceeding, and thus qualifies for Rule 60B relief. Part 1, Section A. This case began as an employment dispute. Petitioner Gary Waetzig is a former employee of respondent Halliburton Energy Services Inc. Following his termination, Waetzig filed a lawsuit against Halliburton in the U.S. District Court for the District of Colorado. He alleged that he was illegally terminated on the basis of his age in violation of the Age Discrimination in Employment Act of 1967, 29 U.S.C. Section 621. In response, Halliburton asserted that Waetzig was required to arbitrate his claim. Waetzig acquiesced and submitted his claims for arbitration. At that point, Waetzig could have asked the district court to stay his federal lawsuit pending the arbitration proceedings, see 9 U.S.C. Section 3, and Smith v. Spizzirri. Instead, he elected to dismiss the case under Federal Rule of Civil Procedure 41A. Under that rule, a plaintiff may dismiss his case without a court order if he serves a notice of dismissal before the opposing party serves either an answer or a motion for summary judgment. Since Halliburton had not yet served an answer or moved for summary judgment, Waetzig's dismissal was effective without any court action. And given that this was the first time Waetzig had dismissed these claims, his dismissal was presumptively without prejudice. That means that Waetzig had preserved his right to refile the same claims in the future. Waetzig lost at arbitration. After a telephonic hearing, the arbitrator issued an award granting summary judgment in favor of Halliburton. In Waetzig's view, however, the arbitrator failed to follow various procedural rules required by the parties' arbitration agreement. To remedy that alleged error, Waetzig turned back to federal court. Section B. Waetzig's next move was procedurally creative. Instead of filing a new lawsuit in federal court attacking the validity of the arbitration award, he returned to the lawsuit that he had previously dismissed. He filed a motion under the old docket number and asked the court to reopen that case and vacate the arbitration award. That move created an obvious problem. As we already explained, Waetzig's dismissal under Rule 41A terminated his case, so in theory, filing a new motion in the case was impossible. The district court was therefore skeptical of Waetzig's gambit. It issued an order asking him to show cause that would justify the court's taking jurisdiction over the motion. In response, Waetzig asserted that the district court could reopen the case under Federal Rule of Civil Procedure 60B. Rule 60B permits a court, on motion and just terms, to relieve a party from a final judgment, order, or proceeding. A court may do so for 6 enumerated reasons, including mistake, inadvertence, surprise, or excusable neglect. The general purpose of the rule, we have said, is to make an exception to finality. The rule attempts to strike a proper balance between the conflicting principles that litigation must be brought to an end and that justice should be done. Here, the district court agreed with Waetzig and awarded Rule 60B relief. First, it held that a voluntary dismissal without prejudice counts as a final proceeding and therefore falls within the ambit of the rule. Second, it found that Waetzig had committed a careless mistake when he voluntarily dismissed his case instead of moving for a stay pending arbitration or administratively closing the case. According to the district court, Waetzig did so under the false understanding that the court would retain jurisdiction over the arbitration agreement. The court thus found that relief was proper under Rule 60B1. And after reopening the case under that provision, the court issued a separate order granting Waetzig's motion to vacate the arbitration award. Footnote 1. The district court additionally found that relief was warranted under Rule 60B6, which permits relief for any other reason that justifies relief. In the district court's view, an intervening precedent from our court affected Waetzig's right to refile a new case, justifying relief under Rule 60B6. Carrying on. Halliburton appealed. Among other things, it argued that a voluntary dismissal without prejudice does not count as a final judgment, order, or proceeding, and therefore falls outside the reach of Rule 60B. The 10th Circuit agreed. It reasoned that Waetzig's voluntary dismissal was not a final judgment or order because the act of dismissal required neither the entry of a judgment nor the issuance of an order by the court. The Tenth Circuit then concluded that a voluntary dismissal without prejudice could not be a final proceeding because, in its view, a final proceeding must involve at a minimum a judicial determination with finality. In so holding, the Tenth Circuit split from other circuits that have considered the issue. We granted certiorari to decide whether a Rule 41A dismissal without prejudice is a final judgment, order, or proceeding under Rule 60B. Part 2. Before reaching that question, however, we first address a preliminary issue related to jurisdiction. Halliburton claims that the district court lacked jurisdiction over Waetzig's motion to vacate the arbitration award. In support of its argument, Halliburton points to this court's decisions in Badgerow v. Walters and Kokkonen v. Guardian Life Insurance Company of America. We need not address the merits of this argument, however, because it presents no barrier to our deciding the question presented. We granted certiorari to decide whether Rule 60B permits a court to reopen a case that was voluntarily dismissed without prejudice. That question is separate from and antecedent to the question whether the district court could exercise jurisdiction over Waetzig's motion to vacate. The cases Halliburton cites prove the point. In Badgerow, we addressed the jurisdiction of federal courts to consider motions to vacate arbitration awards filed under a provision of the Federal Arbitration Act, 9 U.S.C. Section 10A. We held that a plaintiff seeking to vacate an arbitration award must point to an independent jurisdictional basis that would authorize a federal court to decide the matter. In the other case, Kokkonen, we suggested that Rule 60B cannot confer jurisdiction upon a federal court where jurisdiction would not otherwise exist. We reasoned that reopening a case under Rule 60B would not automatically confer jurisdiction over a subsequent motion to enforce a settlement agreement. The upshot of our analysis in Kokkonen was that even though Rule 60B might give a court the power to reopen a case, the rule cannot itself serve as the basis for federal jurisdiction. Although these cases might bear on the district court's jurisdiction over Waetzig's motion to vacate, they say nothing at all about whether the district court had the power under Rule 60B to reopen Waetzig's case in the first place. That power is the focus of our decision today, and it must be addressed before any subsequent jurisdictional question is considered. The procedural history of this case confirms as much. Before the district court could rule on Waetzig's motion to vacate, it first needed to reopen the case. Consistent with that understanding, the court issued two separate orders. First, an order reopening the case pursuant to Rule 60B, and second, an order vacating the arbitration award. We granted certiorari to address the district court's power to issue the first order, not its jurisdiction to issue the second. We leave it to the lower courts to address any subsequent jurisdictional questions on remand. Part 3. That brings us to the question presented. Rule 60B permits a court to relieve a party from a final judgment, order, or proceeding. We hold that a Rule 41A voluntary dismissal without prejudice qualifies as a final proceeding under Rule 60B. Text, context, and history support that interpretation. Section A, subsection 1. To start, we hold that a voluntary dismissal without prejudice is final under Rule 60B. In 1946, when the term final first appeared in the rule, legal dictionaries defined final to mean definitive, terminating, completed, conclusive, last. By way of illustration, Black's Law Dictionary defined final order as an order that terminates the action itself. A voluntary dismissal without prejudice falls comfortably within this definition. The dismissal is the conclusive and last filing on the docket, and it completes the particular lawsuit at issue. And like a final order, the dismissal terminates the action itself. That straightforward reading of final is confirmed by the Federal Rules Advisory Committee's notes, which are a reliable source of insight into the meaning of a rule. In the notes accompanying the 1946 amendments to Rule 60B, the committee briefly explained its reason for adding the term final. According to the committee, the addition of final clarified that interlocutory judgments are not brought within the restrictions of the rule, but rather they are left subject to the complete power of the court rendering them to afford such relief from them as justice requires. The term final was therefore intended to exclude interlocutory judgments from the reach of the rule, and as the committee notes explain, that exclusion makes sense. Rule 60B relief from interlocutory judgment is unnecessary because, with respect to those judgments, a rehearing may be sought at any time before the final decree, provided due diligence be employed and a revision be otherwise consonant with equity. In other words, a court presiding over a case is always capable of revising an interlocutory ruling so long as a revision is consonant with equity. The word final underscores that Rule 60b does not infringe on that inherent and distinct power. After a case is finally terminated, however, a court no longer presides and a party can no longer seek a rehearing on an interlocutory judgment. It is at that point that a court's power under Rule 60b kicks in, permitting the court to look back at the final act in a case and provide relief from that act when appropriate. A voluntary dismissal without prejudice is one such final act. It terminates the case and strips the court of its equitable power to revise its earlier rulings. At that point, Rule 60b is the appropriate avenue for relief. A contrary interpretation would place voluntary dismissals without prejudice into a procedural no man's land. Such dismissals would not be interlocutory in the manner that the committee notes discuss, because they are outside of a court's complete power over an ongoing case. Nor would they be final and thus subject to Rule 60b. Halliburton provides no evidence supporting the existence of any third category. If a voluntary dismissal without prejudice is not interlocutory, then it is hard to imagine that it could be anything but final. Subsection 2. Halliburton nonetheless presses for a narrower definition of final. Specifically, it asks the court to construe final in Rule 60b to mean essentially what it means in jurisdictional statutes like 28 U.S.C. Section 1291, which gives the courts of appeals jurisdiction over appeals from final decisions of district courts. This grant of appellate jurisdiction can be traced back to the First Judiciary Act. And long before the adoption of Rule 60b, this court had developed a rich jurisprudence explaining the meaning of final as it relates to appellate jurisdiction. Halliburton asks us to look to that legal lineage when interpreting Rule 60b. Based on that body of case law, Halliburton contends that a determination is final principally when it terminates the litigation between the parties on the merits of the case. Contrary to Halliburton's suggestion, however, we do not find this body of case law helpful in interpreting the meaning of the term final in Rule 60b. True, we sometimes look to legal tradition when interpreting a statutory term, but we typically do so only when the term is obviously transplanted from another legal source. Here, there is little reason to think that the term final in Rule 60b was transplanted from statutes governing the jurisdiction of federal appellate courts. In that field, the concept of finality plays a distinctive role. It prevents interlocutory appeals from unduly impairing the resolution of civil and criminal cases at the trial level. Under 28 U.S.C. Section 1291 and predecessor provisions, a party that loses in the district court has a statutory right to make an appeal from any final decision. Our decisions defining what the term final means in this context have imposed an important practical limit on such appeals. We have described the finality requirement as the means for achieving a healthy legal system. Without it, too many trial court rulings could be appealed, and the orderly process of a cause would be halted while the appellate court considers all sorts of questions which have happened to cross the path of such litigation. Finality under Rule 60b does not play a similar role. Unlike an appeal filed under the appellate jurisdiction statute, a motion for relief under Rule 60b is discretionary, not a matter of statutory right. Further, Rule 60b relief is unnecessary when a case is ongoing because during that time a court retains jurisdiction to review and modify its decrees. Thus, there is no reason to fear that Rule 60b will be abused to bring about a halt in the orderly process of a cause. And even if such abuse were possible, Rule 60b provides district courts with ample discretion to prevent it. Given these stark contextual differences, it is unlikely that final, as it appears in Rule 60b, was transplanted from the appellate jurisdiction statute. We therefore see no reason to import the understanding of finality that applies in the field of appellate jurisdiction. In the context of Rule 60b, a voluntary dismissal without prejudice is final because it terminates the case. Section B. Next, we hold that a voluntary dismissal without prejudice counts as a proceeding under Rule 60b. Footnote 2. Waetzig additionally contends that a voluntary dismissal without prejudice counts as a judgment. Because we hold that such dismissals qualify as proceedings, we need not decide whether they qualify as judgments for the purposes of Rule 60b. Carrying on. In 1938, when the term proceeding first appeared in the rule, Black's Law Dictionary defined proceeding as the form and manner of conducting judicial business before a court or judicial officer, regular and orderly progress in form of law, including all possible steps in an action from its commencement to the execution of judgment. Other dictionaries define the term similarly. These definitions suggest that the term proceeding encompasses all steps in an action, including the filing of papers that are noted on the docket. Even today, Black's Law Dictionary defines proceeding as the regular and orderly progression of a lawsuit, including all acts and events between the time of commencement and the entry of judgment. Other federal rules similarly treat proceeding as including all formal steps in an action. Take, for example, Federal Rule of Civil Procedure 37. Under that rule, a court may stay further proceedings in a case until a discovery order is obeyed. In that context, a stay of proceedings likely refers to a stay of any further action in the lawsuit, including further docket filings. If read otherwise, the stay would be an ineffective sanction against a party's disobedience. Similarly, Rule 41 permits a court to stay the proceedings until a plaintiff pays the costs of a previously dismissed action. As with Rule 37, that would be a relatively toothless sanction if proceedings did not encompass all further actions in the case. Halliburton and the court below offer an alternative definition. They argue that the term proceeding is given more precise content by the neighboring words with which it is associated. Specifically, they assert that the term proceeding should be read to include the characteristics of the terms that come before it, judgment and order. Since a judgment and order both involve some judicial determination of rights, they say a proceeding should at least involve some judicial action or conclusive determination of rights. Although it is true that statutory terms must be read in the context of their neighbors, that rule cuts the other way here. To read proceeding to require a judicial determination would strip it of any independent meaning. Any formal judicial determination of a party's rights is bound to be in order. So, if the term proceeding covers only judicial determinations, it is hard to imagine what the term proceeding would encompass that is not already covered by the term order. Such a limited reading of proceeding is contrary to the general structure of Rule 60b. When the rule authorizes relief from a judgment, order, or proceeding, it speaks in an ascending order of generality. It starts with the narrowest category, judgments, and then moves to a broader category, orders. Any judgment will generally involve an order, but not all orders are judgments. That suggests that each term should be read as broader than what came before. Just as order encompasses and exceeds judgment, proceeding should encompass and exceed order. It would be odd, therefore, to read proceeding as covering only those acts that are already covered by the term order. Halliburton intuitively grasps this point. To avoid a complete overlap between order and proceeding, it tries to conjure up examples of what might count as a proceeding under its definition, while not being an order. But in doing so, Halliburton only reinforces the common sense conclusion that a voluntary dismissal without prejudice counts as a proceeding. For example, Halliburton suggests that a voluntary dismissal with prejudice may qualify as a proceeding, but there is no reason why a voluntary dismissal with prejudice would count as a proceeding, while a voluntary dismissal without prejudice would not. Both consist in the simple filing of a paper on the docket. Halliburton contends that a dismissal with prejudice is different because it imposes legal burdens, but a voluntary dismissal without prejudice does so as well. For example, Waetzig's dismissal apparently precluded him from continuing to pursue his claims, not because his dismissal was with prejudice, but because the relevant statute of limitations had already expired. In sum, the text, context, and structure of Rule 60b show that the term proceeding encompasses all steps taken in the action, including a voluntary dismissal without prejudice. Section C. Finally, our reading of Rule 60b is buttressed by the historical context in which the rule was enacted. The original version of the rule was based on a then extant provision in the California Code of Civil Procedure, Section 473. that provision permitted a court to relieve a party from a judgment, order, or other proceeding. And prior to the enactment of Rule 60B, the Supreme Court of California had read that provision to apply to voluntary dismissals. According to the California court, a plaintiff who consented to a dismissal to his injury under a mistake of fact, excusable under the terms of the statute, is not barred of relief. And the California court made clear that the existence of prejudice was immaterial. Whether a voluntary dismissal bars a future action need not be considered. If the plaintiff is entitled to relief under the statute, it is not material whether, in its absence, he could have relief either at law or in equity. When read in light of this history, it makes sense that Rule 60B would likewise extend to voluntary dismissals without prejudice. The provision was expressly modeled after a statute that ostensibly permitted such relief. And although the rule has been amended substantially since then, the amendments have always retained the original candidates for relief, judgments, orders, or proceedings. To be sure, the rule now specifies that the judgments, orders, or proceedings must be final, but as we have already explained, the term final does not exclude voluntary dismissals without prejudice from the reach of the rule. There is no reason to think, then, that such dismissals have since escaped the rule's coverage. Part 4. For the above reasons, a Rule 41A voluntary dismissal without prejudice counts as a final proceeding under Rule 60B. When the requirements of Rule 60B are satisfied, a district court may relieve a party from such a dismissal and reopen the case. We express no view on whether that relief was proper in Waetzig's case, nor do we reach the question whether the court below could exercise jurisdiction over Waetzig's motion to vacate the arbitration award. Those questions are left to the court below on remand to the extent the relevant arguments have been preserved. The judgment of the 10th Circuit is reversed and the case is remanded for further proceedings consistent with this opinion. It is so ordered. And that does it for the opinion in this case. Much shorter one than the previous episode. And honestly, I don't know that I have all that much to say about it. It seems pretty straightforward. Probably why it was decided 9-0. I don't know, probably the closest question to me seems to be whether, or I guess what final means, and, whether final should be read in the same sense that it's read in the appellate jurisdictional statute mentioned in the opinion. And I think there's good reasons that the court says, no, we're not going to read it in that same sense because these are different statutes, or different laws, and they serve different purposes, and, so there's good reason to read the word final differently. Maybe if it was in the same statutory provision, or a very, related statutory provision, it would make sense to read the word final the same way in both contexts, but I think the court justifiably says, no, there's good reasons to read final slightly differently here. And looking at the dictionary definitions, it seems to make sense that these, voluntary dismissals without prejudice would be final under the meaning of that term. Because, it is a, a proceeding that terminates the case, and then whether it's a proceeding or not, I think is even clearer. Yeah, of course, it's a proceeding in a suit. A proceeding doesn't have to be, a judicial determination, or, an order from a court. It's just something that happens in a case, and that can include filing papers on the docket. So, yeah, decision makes sense to me. Apparently it made sense to the other 8 justices that signed on to it. So, yeah, and it makes sense that the court wouldn't address the jurisdictional issue that it mentions because, well, it doesn't need to, and the court doesn't like to decide things that it doesn't need to a lot of the times. So it says, well, you lower courts can deal with that because that's a separate issue. We're just answering this question that, presents this this circuit split. So with that, if I may ask you, my friends on the other side of the screen, please like, share, comment, follow the podcast wherever you follow podcasts. And if you'd like to support the podcast, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members have access to episodes early and any bonus or exclusive content, and they can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode where we will continue on through the court's 2024 term. Until then.